Before we begin, we'd like to give special thanks to all of our sponsors for making this event possible each year. Specifically, thank you to CRL FormFox for being our title sponsor for 6 consecutive years. And thank you to our platinum sponsors, Psychmedics, OraSure Technologies, Quest Diagnostics, and Veriforce.
Hi, and thank you so much for joining us for another session. This session will be on drug testing updates focused on industry challenges, threats, and tools. Today, we're joined by Bill Current, President and Founder of Current Consulting Group. Bill, how are you?
Doing great. Thank you, Thomas.
Absolutely. Well, before we jump into your presentation, I do want to remind all of the attendees that if they have any questions, they should use the Q&A button at the bottom right of the player. Any questions that we're unable to answer today, we'll reach back out to you after Day with DISA. And then additionally, we'll make a copy of this presentation available for download on the Materials tab after the session. With that being said, Bill, the floor is yours.
Thank you. It's great to be with Day with DISA again. I just love this conference that you put on every year, and I just want to tip my hat to DISA for doing this. It's just a tremendous service, certainly to your clients, but to the whole industry. So thank you for doing it, and thank you for inviting me to speak this year. I'm excited to be doing it. We're going to talk a little bit about state drug testing laws, and I'm going to take a deep dive into the 2 new state laws that everybody's talking about, California and Washington. But let me set the stage with a few slides about basic state law issues that every employer should understand. So a little background. I got into the drug testing business in the late 1980s. And in 1990, while I was working at the U.S. Chamber of Commerce, I wrote a book called A Guide to State Drug Testing Laws and Legislation. And at that time, there were only 16 states that had drug testing laws. So I had them all memorized. It was really easy to sort of stay on top of it, answer people's questions. Shortly thereafter, in 1991, the Omnibus Transportation Employee Testing Act came out. That was easy to follow. It was sort of uncomplicated in those days. Today, however, there are literally hundreds upon hundreds of state laws and court decisions that can have a direct impact on workplace drug testing. And every year, there are hundreds. This year alone, there were over 500 bills introduced at the state level that, if passed and enacted, could have had a direct impact on workplace drug testing. So everything has changed dramatically since those early days when I wrote that book. It's way out of print for one thing, but it's just out of sync with where we're at with state laws nowadays. And in 2023, there were 3 significant developments that affect workplace drug testing. First, of course, the big news was that the U.S. Department of Transportation issued final regulations for lab-based oral fluid testing. Now, it went into effect, but really the utilization of these new regulations is pending a number of different things, including the certification of at least 2 laboratories to conduct oral fluid testing. So even though some employers want to get started with it, they really can't do it yet until some of those qualifications are met. The second big development was the continual legalization of marijuana at the state level. So we saw Minnesota and Ohio, for example, pass recreational marijuana laws. The Ohio law, pretty friendly toward employers with some protection language written into the law for employers. Minnesota, on the other end of the spectrum, with some very restrictive language that would affect employer drug testing for marijuana. And then the third thing, and this just went into effect on January 1st, but all throughout 2023, we were talking about the 2 new laws in California and Washington, as I mentioned, that have now gone into effect January 1st. And I'll talk about those 2 things, those 2 laws in a moment. But let's set the stage with a few basics, because these basics will apply in every state or many states, and they'll affect how an employer puts together a drug testing program. And compliance is your best legal defense when somebody challenges a drug testing result. So it's important to understand that there are some states that have mandatory drug testing laws, meaning that any employer in those states must comply with that law. Minnesota, Iowa, those are 2 good examples of states with mandatory laws. And then there are states with voluntary laws. And I know that sounds a little bit like an oxymoron to have a voluntary law, but what it means is that employers may voluntarily choose to participate in a state program on drug testing that will yield to those participants certain benefits. Like here in Florida, where I live, for example, employers can join this voluntary program and qualify for a 5% discount on their workers' compensation premiums by conducting drug testing in the prescribed manner offered by the state of Florida. There are about 16 states, Florida, Georgia are two examples of states that have these types of voluntary laws. Now, employers are not required to join these voluntary programs, and in some cases, they couldn't qualify. Self-insured companies typically cannot qualify. But it's voluntary, and if you choose to do it, there are certain incentives that are in place to try to make it worth doing. There are some states like Illinois and West Virginia that have industry-specific drug testing laws that apply just to employers in those industries. Mining industry in West Virginia, for example, or public works contractors in Illinois. And many of those industry-specific laws, which again only apply to companies in those industries, have what I would call sort of DOT look-alike requirements. They're not DOT, but they've adopted the DOT or the Part 40 regulations for how drug testing is conducted, and you see similar language in those types of laws. Additionally, now I mentioned the workers' comp premium discount law that we have here in Florida, but in addition to those types of voluntary laws, most states have either an unemployment comp denial law or a workers' comp denial law, where written into the law for, let's say, workers' compensation denial, written into the law is language that allows employers to move to deny benefits if they can prove that the individual was either had drugs in their system at the time of the accident, or in some cases, even though it's sort of antiquated language, they have a positive drug test result that, quote unquote, proves impairment. Now, nobody claims, DISA doesn't claim that a drug test result proves that somebody's impaired, either legally or scientifically. But some of the language in these older laws makes that implication, and we don't really sort of endorse that, but it doesn't change the fact that in some states, employers can move to deny workers' comp benefits if they have a positive drug test result following an accident. And in many of those states with those types of laws in place, or let's call them regulations, the procedural guidelines for how to do drug testing, in order for that result to be valid in a motion to deny benefits, they again sort of mirror Part 40 or the DOT regulations. They're not DOT regulations, but they use similar language. And so you have to use a certified laboratory. You have to have an MRO verify the results, things of that nature. And so that's another area in which employers may want to take into consideration those types of regulations when putting their policies together. The big issue, of course, now for the last 10 plus years and continues to be so today are the legalization of marijuana laws, the medical cannabis laws and the recreational cannabis laws. And in some states, those marijuana laws have language written into them that affects workplace drug testing programs. And there's just so many examples, it wouldn't be fair to try to get into all of them now. But if you have specific questions about a state that you're in, and can you drug test for marijuana in that state, or what can you do with a positive drug test result, just let us know. We'll respond to those questions after today's presentation. We'd be happy to do that for you. But it's important to review those laws when putting a drug testing program together, because some of those laws would have a direct impact on how you drug test or how you drug test for marijuana. For example, Nevada, where you would be restricted in taking action or refusing to hire somebody based on a positive test for marijuana if certain conditions are met. So again, lots of details on a state-by-state basis there, but something that you want to take into consideration when looking at state laws and how they affect your drug testing policy. And then the final category is case law. There are some states that don't have a mandatory law and they don't have a voluntary law, but they have a lot of case law. So somebody might assume that California, for example, has a mandatory drug testing law that is very restrictive. That's restrictive toward employer drug testing programs, but that's not the case. Actually, in California, there is no mandatory drug testing law, except I'm going to talk about this new marijuana law and how it affects drug testing. But in California, there's a lot of case law. And over the last 25, almost 30 years now, these case law decisions have sort of governed how employers conduct drug testing in the state of California, when they can do random testing, for example. That's a big part of it. So in California, for example, they have a laboratory licensing law that on the surface might appear to restrict or prohibit rapid result testing using a point of collection testing device. In reality, in California, the law specifically does not mention the workplace. It doesn't include the workplace in its restrictions. So technically, you can do rapid result testing in California. However, and I know a lot of employers do, and a lot of drug testing providers provide that service, but some employers prefer to use a laboratory, and that, of course, is okay as well. But it's important to take that into consideration. States like California and New York in particular come to mind that have laboratory licensing laws that could affect drug testing. But case law decisions in states like California actually form sort of the procedural guidelines for when and who and how drug testing gets conducted in those states, even though they don't have a mandatory or even a voluntary drug testing law in California. Now, in addition to state laws, and I'm only going to touch on this because this would be an entire presentation all on its own, but you have federal regulations. And the most common, of course, are the U.S. Department of Transportation, DOT, Drug and Alcohol Testing Regulation, that apply to truck drivers and airline pilots and mass transit authorities, et cetera. And those regulations apply to employers specifically who are covered by them. Outside of those regulations, employers in a particular state would be governed by the state law or the case law that exists in that state. And I mentioned the DOT regulations only because as you read certain state drug testing laws, you'll see a similarity between the state law and the language of the federal regulations. In many cases, like, for example, in Illinois' industry-specific law that applies only to public works contractors, it's very DOT-oriented, the process that the employers in that industry have to comply with. And so it's always important to look for any kind of Part 40, SAMHSA, DOT type of language when a state law talks about how to do drug testing or when to do drug testing, et cetera. Good to know those federal regulations, and they're sort of the blueprint. You don't have to follow them if they don't apply to you, but many employers like the comfort of doing that because the regulations exist. I'm not a proponent of that necessarily, but I know some state laws actually include that language in their statutory requirements. And how the laws work together is important to understand, because if you're a multi-state employer, you have to comply with all the laws that apply in the states where you do business. You have to comply with multiple state laws. And so one of the things I know that DISA does is that if you're a multi-state employer, and let's say you're in 35 different states, you're going to have a customized policy that makes it possible for you to comply in each of those states according to those particular laws. So you want to make sure that you understand that you can't base your policy on just the headquarters state that your company is located in, but you have to comply with all the state laws, and that may require having separate addendums to your base policy. Now, I mentioned Illinois earlier, just as an example, okay? No general drug testing law, so all methods of drug testing are permitted, but a mandatory law does exist for public works contractors and police officers. And employers that wish to deny workers' compensation claims also have to look at those regulations because they have specific drug testing language built into them. Medical cannabis in Illinois, not too bad. The original version of it was a little bit unfriendly for employers, but they've gone back in and they've changed that. But the new relatively new recreational cannabis law in Illinois is a little bit more restrictive when it comes to drug testing. Look at that second bullet. It is unlawful for employers to refuse to hire or discharge any individual because of the individual uses lawful products off the premises of the workplace during non-working and non-call hours. That's interesting because a lot of states have these lawful use laws where employers can't discriminate against somebody because they smoke, for example. And some of those laws are now being used to protect, quote unquote, legal users of marijuana in those same states, and recreational marijuana in particular. Because with medical marijuana, the user typically has some type of a registration card that shows that the state has authorized them to use marijuana under certain circumstances. But with the recreational laws, like we're seeing here in Illinois, some of these lawful use laws are coming into play. Okay, so let's look at a few trends in drug testing specifically. This is going to be a 30,000-foot view of California and Washington. Then I'll do a deeper dive. So in 2022 and in 2023, California and Washington enacted new laws that affect drug testing for marijuana. They're very, very well known by their legislative names. In California, AB 2188, and Washington, SB 5123. Basically, okay, again, the 30,000-foot view. Depending on a number of circumstances, these laws prohibit employers from discriminating against employees based on the individual's off-duty, away from the workplace use of marijuana. The new laws specifically prohibit employers from using results of a drug test that solely identifies the presence of the so-called non-psychoactive metabolite of cannabis, and we'll talk about that more in a minute. The California law applies to both pre-employment and employee or post-hire testing, like reasonable suspicion, post-accident, random, whereas the Washington law only applies to pre-employment testing. Some employers may be under the false assumption that these laws prohibit all testing for marijuana. And it could be tricky from a legal perspective because these are new laws, and there's certainly going to be some legal challenges if you continue testing for marijuana. But I'm going to talk about that in more detail here in a second. The laws don't specifically prohibit testing for marijuana, but they place some pretty heavy restrictions on testing for marijuana. And I'm going to get into some exceptions that were written into both of the laws here in a second, okay? But it's important to know that if it's a drug testing method that solely reveals the presence of a metabolite or the quote-unquote non-psychoactive metabolite of marijuana, like urine testing, for example, then you can't use the results of a urine test to take any type of adverse employment action against somebody who tests positive, whether it's an applicant or an employee in California or an applicant in Washington. Interestingly, though, oral fluid, which was approved last year by DOT, and breath, which is sort of an emerging technology that's not fully out there yet, but both of those methods reveal the presence of the parent drug, the psychoactive tetrahydrocannabinol, or THC, in the donor specimen. Will they be allowed? I put a question mark there because we really don't know. As you read those two laws, they don't specifically say that you can do oral fluid or breath testing for marijuana, but there is some language in there that may reveal that. But I want to emphasize the question mark at the end of my sentence there. Okay, so let's talk about California. Let's take a little bit of a deeper dive. Okay, this goes back, as I said, to 2022. Governor Newsom signed AB 2188 into law. So it's a law, and it went into effect January 1st of 2024, this year. The bill states, look at the second bullet there, that although tetrahydrocannabinol can indicate impairment and cause psychoactive effects, after metabolization, it is stored in the body as a non-psychoactive metabolite and therefore does not indicate impairment. Let me back up and say that professionals in the drug testing industry never claim that a drug test proves either scientifically or medically or legally that somebody's impaired. We don't make that claim with drug testing. We do claim, though, that a positive drug test result that has been confirmed at the lab and verified by a medical review officer proves that the individual has drugs in their system, okay? But in California, they're concerned about the identification of what they call the non-psychoactive metabolite of cannabis. So look at the third bullet. As such, drug tests that do not indicate that an employee is impaired, okay, we agree with that, but rather indicates that there's the presence of the cannabis metabolites in the system. And the bill stated that employers now have access to several other types of tests that don't rely on the presence of the non-psychoactive cannabis metabolite, such as impairment tests that are not drug tests at all, or tests identifying the presence of THC in the body. As I mentioned, oral fluid and breath, and blood for that matter, identify parent THC, or the psychoactive metabolite. Now, taking it a step deeper into the law, employers are not permitted to discriminate. Discriminate's an important word when looking at marijuana laws in any state. Employers are not permitted to discriminate in terms of hiring, termination, conditions of employment, or otherwise penalize an individual if these two conditions come into play. The individual uses cannabis off the job and away from the workplace, so they didn't bring it to work, they didn't use it at work, etc. And a required drug test finds that an individual has non-psychoactive cannabis metabolites in their hair, blood, urine, or bodily fluid. Now, hair, blood, urine, or bodily fluid are words taken right out of AB 2188. Employers can, however, discriminate, if you wouldn't use that word, in hiring, terms of, or conditions of employment, or otherwise penalize an individual based on a scientifically valid pre-employment test, or in the case of California, post-hire test, conducted using a method that does not screen for the non-psychoactive metabolite of cannabis. Let me put that big question mark back on the screen, okay? Theoretically. We don't know for sure whether oral fluid or breath are going to be permitted. Some employers may want to shy away from testing for marijuana altogether. They may want to instead, say, for example, add fentanyl to their drug test panel. That would be a wise thing to test for fentanyl, especially with, you know, the situation we're in right now with the sort of boom in fentanyl abuse and deaths. But we don't know for sure that we can test for marijuana in California and Washington with oral fluid or breath for that matter. Yes or no, that's yet to be determined. Okay, but it's important to know that they are drug testing methods that detect the parent drug and not a metabolite. But a lot of questions still to be answered there. Employees cannot possess, be impaired by, or use cannabis on the job. And employers are not impacted in their rights or obligations to maintain a drug-free workplace program. So that's all right out of AB 2188. Now, there are some exemptions. For example, building and construction trade, that is exempted from this new law in California, meaning if you're in the building and construction trades, you can still test for marijuana using urine or hair for that matter. It's up to you, but they're excluded from the restrictions in AB 2188. Additionally, if you're an employer that uses employees or hires people for positions requiring federal government background investigations or security clearances, you too can continue to test for marijuana with urine. You're exempted from AB 2188. And the bill also does not affect any other state or federal laws that may require employers to drug test a certain way. For example, the new law in California does not have any impact on DOT drug and alcohol testing, meaning you can still test with urine, and right now that's the only testing method that's available. Oral fluid will be soon, but you can still test with urine under the DOT regulations. It's unaffected by AB 2188. Now let's take a little deeper dive into SB 5123 in Washington. Again, as I mentioned, this law was passed in 2023. It went into effect January 1st this year, 2024, and it only applies to pre-employment testing. So you can test employees for marijuana using urine or hair, as if that's your choice. If you've been doing that, you're not restricted from doing that. But for pre-employment testing, the same restriction that we just talked about for California would apply, meaning you can't take action, you can't refuse to hire somebody based on a drug test that reveals the presence of the non-psychoactive metabolite of marijuana. Now, again, you'll see on the screen here, I put oral fluid and breath on there. I'm not saying that you can do oral fluid or breath testing in California or in Washington. I'm just saying those are two testing methods that don't rely on revealing the presence or identifying the presence of the non-psychoactive metabolite of cannabis. They actually identify the parent drug. But can employers use them? Only the future can tell, okay? There are some interesting things about Washington that are a little bit different than California. They're very similar. You see that the Washington law also includes the phrase scientifically valid drug screening conducted through methods that do not screen for the non-psychoactive cannabis and metabolites. That's in the Washington law also, okay? But there's nothing in the Washington law that prohibits an employer from having a screening program from testing employees with urine or hair, if that's what you've been doing, because it only applies to pre-employment testing. The other thing is, I'm not going to go through all the words on this page, it's a lot, but in Washington, there are a lot more exceptions to the law than what we saw in California. There's tons of them. You have to just go through the statutory language to get through it all. But I want to point out the last two. Of course, the airline and aerospace industries are big time employers in the state of Washington. Those industries are completely exempted from this new restriction in California about testing for marijuana with urine and hair for pre-employment testing. Also, they included this sort of ambiguous, all-encompassing catch-all language, safety-sensitive positions for which impairment while working presents a substantial risk of death. Those occupations are exempted from the law as well. What are those occupations? The statutory language doesn't actually say, but there are a lot of occupations that probably qualify for that category. And so that's a deeper dive into California and Washington. We're probably going to see more laws like those two popping up around the country. So employers need to be prepared to determine how you're going to react to them. If you're going to continue to test for marijuana, if those restrictions apply in your state, or if you're going to use some type of alternative testing method. We just don't know the answer to that question yet, but certainly time will tell, and then we'll be able to give you some better advice on that. But right now, the probably word of the day is caution. And so with that, let's take some questions.
Thank you so much for your time, Bill. Some questions. I know we're tight on time, so we'll fly through these as quick as we can. Is there an expected timeline for the DOT oral fluid to get right?
If I could answer that question, Thomas, I would be a rich man. But hopefully sometime in 2024.
Awesome. Where can I get a list of voluntary laws and their benefits? You mentioned several examples.
Yeah, you can get those through DISA. We'll provide that list, and then they can share it with whoever would like to know.
Okay, so if you would like a copy of that, let us know in the comments, and we'll make sure we get you a copy of it after this presentation. Several state-specific questions came in about medical or recreational cannabis. Again, we'll have Bill, we'll provide those questions over to Bill and get answers out to everyone after the presentation. If federal government legalizes marijuana or it moves from Schedule 1 to Schedule 2, will that make marijuana testing illegal across the country?
No, I don't think so. We know we're fairly certain that, for example, the DOT regulations would be unaffected by any kind of federal move on marijuana. But it will be like a lot of other things where it'll be up to the states. And so it won't make testing for marijuana illegal in the same way that alcohol being legal doesn't make alcohol screening illegal. But it may place new restrictions in some states where no restrictions exist right now. So that we would have to see. But generally speaking, I would say no, it will not outlaw drug testing for marijuana.
Gotcha. If we have an employee that works in multiple states, which laws should we hold them to? And similarly, if we are hiring someone in one state for a job in another state, do we hire them? Which laws do we hire based on?
Yeah, so that's a two-part question. So the first part is generally the law that applies is the law where they're domiciled. So if somebody works all over the place, but they live in Indiana and they work out of your office in Indiana, even though they're spending extended periods of time in other states, it's really the Indiana law that applies to those workers. If somebody is being interviewed in Indiana for a job in Illinois, that question comes up a lot, and we generally would advise employers to, let me take that back. We would inform employers. We don't want to advise them. That's up to them to make this decision. They can talk to their labor attorney about it. But to comply with the law in the state where the individual lives right now, and then once they're hired and they move to Illinois, then they would be covered by any kind of Illinois laws.
Gotcha. What about remote work, Bill? I know that's more and more common.
Yeah, and that really started to become an issue in 2020 during COVID when so many of us were working from home. And a lot of companies have continued to employ people remotely. And the law that applies is typically where those individuals live. So if all of my workers, for example, for current consulting group, work remotely, and they're all over the country, and so the law in the state where they live is the law that applies to them for our drug-free workplace program.
Gotcha. In California, you had said construction trades were exempt. Does that mean construction companies can take adverse action for positive marijuana tests?
Well, I'm not going to advise anybody to do that under the circumstances in California or Washington or a number of other states, except to say that they specifically excluded the construction trades industry from the new law. And so that what it does mean is that employers can continue to do pre-employment and post-hire testing with urine and hair, but I'm not going to advise them on whether or not they can take adverse employment action, except to say that, you know, whatever their normal policy is, run it by your labor attorney and make sure that under these new sort of circumstances, you're comfortable continuing to do that.
Perfect. In Washington, we can still random test for THC, correct?
Yes. In Washington, this new law only applies to pre-employment testing. So I would not do urine or hair pre-employment testing in the state of Washington, except if possibly what we're talking about falls under that long list of exemptions that I sort of alluded to during the presentation. But you can test employees randomly, post-accident, reasonable suspicion with urine or hair for that matter. Those testing methods are not affected by the new law in Washington when it comes to post-hire testing.
Gotcha. And then the last question about Washington is regarding safety-sensitive positions and defining roles as safety-sensitive. Is that something that's left up to the employer?
A good friend of mine told me recently that we don't know because these laws are so new, and there was a lot of, you know, sort of guidance language that was not included in the laws, and that's one of them. It doesn't define certain things like that in the Washington statute. The Washington statute is well written. I may not agree with everything in it, but it's well written. But they didn't give us any guidance on that. And so I truly don't know the answer to it, but I would say, again, contact your labor attorney, make sure you're comfortable with whatever you decide to do, and make sure you write it into your policy and you inform your employees and applicants of which positions are considered safety sensitive, and then go by that. But the key here will be to make sure that it's in your policy and your people are aware of what it says.
Awesome. Well, hey, Bill, thank you so much for your time today. Greatly appreciate it. And everyone that joined us again, thank you so much for being a part of Day with DISA.